A very warm good morning to one and all present here. We have gathered here in this auspicious day for the webinar on workshop on intellectual property rights and intellectual property management for startup of Department Commerce CA, Sri Akhilandeshwari Women's College, Vandavasi. It's a pleasure for me to be a host in this program. A very morning welcome the sun to behind the wonderful day. Here comes our eminent person, Mrs. Varalakshmi ma'am, head and assistant professor of Commerce CA, is going to deliver the welcome address. Welcome ma'am.
Good morning to one and all to joining us. I take the privilege to express my profound happiness to the workshop on intellectual property rights and IP management for startups of our esteemed institution organized by the ICC and the Department of Commerce CA. First of all, I would like to invite our respected and beloved chairman, sir, Tiruvalar Line B. Muniratnam, sir, who has established this institution only for the welfare of the women students for the 25 years. I would like to extend my valuable welcome our youth and enthusiastic secretary, sir, Thiruvalalai B. Ramadan, sir, who is always motivating and inspiring the faculty members and students all their endeavors. I give immense pleasure to welcome our most respected and beloved principal, Dr. S. Rukmani ma'am, who is always thinking and guiding for the development of our college students in all fields of education. Welcome, ma'am. Start and shine and stars shine at the bright daylight. I would first of all, it is our time duty. Welcome our chief guest, Mr. R. Gautam, a young and energetic researcher, is presently pursuing his doctorate of philosophy at the Department of Commerce, College of Science and Humanities, SRM Institute of Science and Technology, Atangalottu, Tengalpattu District, Tamil Nadu. He worked at Madras Christian College, Tambaram East, Chennai, as an assistant professor in the Department of Commerce. Mr. Gautam is the area of specialization is teaching include accounting, finance, management. He received his education both inside and beyond India. It is the worth nothing here. He is an alumnus of Madras Christian College. Taxation, accounting, finance, management, and entrepreneurship are among his research interests. His scientific interests are influenced by his involvement in a variety of research and development initiatives at the age of 26. He has published over so high quality research articles in prestigious publications and presented research papers at national and international conferences. He has received a number of awards including international and institution of organizing researchers Young Researcher Award for his outstanding contribution to the field of finance. And it should be noted that at the age of 25, he holds national records in the India Books of Records category, maximum research paper written and published by an individual. His work has also been recognized with the Best Paper Awards at the many national and international conferences organized by a variety of renowned Indian institutions. Given Mr. R. Gautam's energy and imaginative mentality, he has been welcomed as a resource person by renowned institutions throughout India at the tender age of 25. His investigation attitude has also generated an outside audience. He has been asked to appear a resource speaker at many conferences in the Philippines, the United Kingdom, Japan, and United States of America. Mr. Gautam as a developing young person and regarded as a mentor and a role of model and like-minded young, youngsters and youngsters, co-workers, and he is continuously motivating people and pursue their goals and achieve success. Welcome, sir. Once again, I welcome all of you, sir. Thank you.
Thank you, ma'am. The president is known as the first citizen of a country. So, would like to welcome the captain of the ship, our most respected principal ma'am, Dr. S. Kumari ma'am, to begin the presidential address.
Good morning, one and all present here. Most respected Chairman Sir, beloved Secretary Sir, dear HODs of all the departments, and my special thanks to our HOD, Ms. Varalakshmi, HOD of Commerce CA, and the faculty members and participants from other colleges, other institutes. I'm very happy to address this webinar on IPR, organized by Department of Commerce CA, Sri Aglandeshwari Women's College. First of all, I congratulate this Department of Commerce CA for choosing this right topic, right time. Today, the whole planet has with critical situation, and that research area is intending all in IPR. So in NAC and everywhere, they are asking for IPR only. So our students should know, our students and our faculty members should know the detailed, clear about, should be clear in these IPR factors. So now I have to thank our resource person, a renowned research scholar, young and energetic Gautam from SRM Institute of Technology. He's having lot of, now you might have heard about him from Ms. Varalakshmi. So he's full of energy with dedication, commitment. See, you can see this in this webinar. You can take the source from him. He is going to give you lot of resources. Students who are attending this webinar, please take a further from him and use this webinar as much as you can. Thank you so much, Gautam, for accepting our invitation in your busy schedule of research. I heard that, and I have seen that you are doing lot of webinars in lot of institutions. So my encouragement and my wishes, blessings will be always with you, my son. Thank you so much for accepting our invitation. I should thank Mr. Bala also for this. I asked him, he only, without hesitation, he told you can ask Gautam, and he only gave your number and the contact. So I should thank him also. Yesterday also, his webinar, his session went on 2 hours and 30 minutes. So it was very nice. It will today also it will be nice. So students, take lot of resources from him. Use this webinar as utilized one. Thank you so much. I should thank all my students and then outside participants and this HOD for organizing such a webinar like this. Thank you. And for IAC president also, this is going to be IQAC as well as IIC. So for that also, I should thank Dr. Tamilarasi for helping me, supporting me like this. Thank you, one and all. Carry on, Gautam. All the best.
Thank you, ma'am. Thank you so much. So before I start my today's session, I would like to extend my sincere thanks and gratitude to the chairman and secretary of Sri Aglandeshwari College for Women for having arranging this wonderful session on intellectual property rights. I also express my sincere thanks and gratitude, as pointed out by Principal Ma'am, to Professor Balamurali sir from DG Vaishnava College for having introducing me to the eminent people over here. And I also extend my sincere thanks to beloved Principal Ma'am, Dr. S. Rukmani Ma'am, for her consistent support and blessings to me. I'm really happy for that. And I also would like to thank the head of the department, Varalakshmi Ma'am, for her continuous support. Since the day one we planned for this program, Ma'am is consistently in touch with me. As well as Rukmani Ma'am, both Ma'am are being consistently in touch with me to ensure that the event is going smooth. So I also thank Lakshmi Ma'am for that. And I also thank all other organizers, coordinators who are not who have been not shown on the spotlight, but they have been really working at the backside of the program for to make sure this is going to happen at the right time and the right place. So all those who have not been in the picture but still giving your hard work for this program, I express my sincere thanks to you all as well. And I feel very energetic today. Why? Because I'm also meeting my one of the sources of energy, right? My students, right? I used to address any category of students as my students because I really love the students community, and I also really happy and feel energetic when I meet the young minds, right? So without wasting much of the time, let me start today's presentation. Just let me know whether my voice is audible and my slides are visible.
Yes, sir. Audible, sir.
Yeah,
Visible.
thank you. Is my screen visible, madam?
Okay. Yes, sir.
Thank you, madam. Thank you so much. So today, this is the topic given for me about today's webinar on intellectual property rights and IP management for startups. So I would like to start this presentation with with the topic itself. Why this is a matter of significance. I hope the term intellectual property rights itself communicate to you lot of things, right? The term IPR or intellectual property right itself communicate to you a lot of things. So what is that, sir? What is that it is communicating, sir? Right? So split this term into three words: intellectual property and rights. Right? What is mean by intellectual? Right? When I find somebody else doing something which anybody others cannot do, I say he is an intellectual person, right? So with permission, I would like to take few names from this audience then and now during my presentation. For example, I could see one name, Mohana Devi, right? So when I will call some person as an intellectual, when I find Mohana Devi is doing something extraordinarily well, which others cannot do, so in that case, what will I say? Mohana Devi is a very intellectual person, right? So that is mean by intellectual. Now coming back to property, right? Sir, what is mean by property? Sir, I know property like land, plant, and machinery, all these things, right? So we do not mean property here. And since we are from commerce background and especially in business law, right, Indian Contracts Act or Sale of Goods Act, if you take all these things, instead of using the term ownership, what they will use the term called as property. You can go and check there also. They'll topic itself will be transfer of property. Transfer of property means transfer of ownership. So here property means ownership, and rights, it's nothing but you all know this is my right. You claim some ownership over. So that is the term intellectual property rights. In simple terms, I will put the intellectual ownership right. Why this is intellectual property rights? Because you have created something through your efforts, to using your knowledge, skill, and application of mind. You have come up with something new, right? Completely a new thing through your intellectual process. You have come out of that particular one, and as it is an invention or an innovation, arising out of your hard work, out of your mind, you have complete rights to claim rights over that particular invention which coming out of your mind. So that is the reason behind intellectual property rights. You can say this is the thing, right? I have invented, so I have every right over it. Nobody can copy from me without my permission, right? So that is intellectual property rights. And we are also going to discuss about how this intellectual property rights can be used by startups today. So that is the perspective in which we are going to deal today's webinar, right? So first let us see what is the meaning of intellectual property, right? Intellectual property means simple creation of mind, right? Creation of mind. So something unique, it is coming out of your mind, right? You are going to invent something, or you are going to come up with new idea which is going to be arising. So IP means intellectual, means it is connected with mind, so it is a creation of mind. So who is creating that particular invention? It is you. So as such, you have every right as a creator over it, right? Who is a creator? Somebody who creates, we call them as a creator. So you have the rights over your creativity. That is all very simple. And why this has become a talk of the town, right? Why this has become a very talk of the town nowadays, right? I'll just give you a very few examples, right? Very practical real life examples, right? And this problem was felt nearly 20 to 30 years back itself. Many countries, they were facing this problem, right? It's not only you and me individual problem. This intellectual property, it has now become a universal problem. Protecting the intellectual property rights has become a universal problem, right? So what is that universal problem? For example, I don't know how many of you have here with you a computer or a laptop, right? Whether you have or no issues, but every time have you seen, sometimes especially you are using the Microsoft OS, right? Whether it's Windows 10 or Windows 8 or XP, Windows 7, whatever OS that you are using. Suddenly, after few days, how many of you have noticed it will show, right? Your Windows is not genuine, right? The laptop, the display, in the front display, in the below, right below the startup tab, you will find one pop-up coming up. Your Windows is not genuine, right? How many of you have noticed that, right? So that means you are using an operating system software which is not a genuine one. It is a duplicate one. It is a copied one. Now, tell me, is this a loss for people? Is this a loss for Microsoft company? Is it a loss for a Microsoft company for using a duplicated version? Obviously, the answer is yes. Because it is the Microsoft company which has created this OS. Windows 10 and now 11 is also coming up. I already come up. Okay. Now what is happening? Microsoft company, what it is doing, it has invested crores and crores of money in this particular business, and it has created a beautiful software OS which is Microsoft Windows 11. And what people are doing, easily they are copying and they are duplicating all this work, and this will create a problem for the business, because tomorrow if that particular duplicated version of Microsoft software is going to create a problem, what you will think? Microsoft is waste, right? Microsoft is waste. It is creating so many problems. I'm going to look out for some other operating system softwares. So this is a huge loss in terms of business wise also. So that's why, like this, there are many other brands, businesses, commercial purposes. There they are faced so many problems. because of this reputation which they have gained. And that's why protecting these kinds of intellectual property has also been taken into by world organizations, and this has become a talk of the town. Just to give you a very simple overview about the background of IPRs. So now let's talk about what are all the different kinds of IPRs or IPs, intellectual properties, and rights are associated with these kinds of properties also. So what are those things? What are the different kinds of IPs, sir? First one is patents. Second one, trade secrets. Third one, copyrights. Then trademarks, industrial designs, and others. So these are all the broad different kinds of intellectual property rights. So 6 types, right? So let's see one by one. Okay. First one, let us talk about patent, right? So you can ask me, sir, what is mean by patent, sir? Right? What is mean by patent, sir? See, patent is a right which is given by the government, right? Government will give you the right. Say, for example, I could say a name, Deepika. Say, for example, Deepika is going to come out with a new machine, right? She's using her mind and she's now developing a new machine, right? And she wants to get and come. This is a completely new invention for Deepika. So now what they are going to do, she wants to protect that machine in the sense not from theft or all such things. She wants to protect that idea so that some other person also see the machine invented by Deepika and create a similar machine like that. So to protect all such inventions only, patents are being given by the government, right? It is an exclusive right given by the government, right? Provided, sir, for any invention, can I get patents or no? Right? It should be completely new. And another important thing, there should be some industrial application. Some industry should, your invention or your innovation should some way or the other should be useful for any industry. It can be any industry. At least if it is going to be used in any one industry also, no problem. But there should be an industry application. So what is the use? What is the benefit if I am going to file a patent and I am going to get a patent for my inventions? So say for example, if you are granted a patent, right, you can get an ownership over your invention, and if others want to use it, say for example, I want to use your idea, I should get Deepika, shall I use your idea? There's some proper procedure that has to be followed, and if Deepika says yes only, I can use that particular machine or make use of those machines. So that is patent. So what are the characteristics of patent, or what are the features of this patent? First thing, these patents, who's going to give me this patent, right? Normally patents are given by national or regional patent office. For example, in India, we have Indian Patent Office, right, which grants you the patents, right? So normally who will give you this exclusive right? It is given by the national or regional patent office. First point. Sir, how long I can protect this, sir? You can ask me the next question. Okay, sir, now I am going to get my patent. Is my patent is a lifelong time? Till I die, can I get the patent? No. See, normally patents will be granted for a maximum of 20 years, right? Say for example, today you are going to file an application, means from today, from what is this year, 2021. So till 2041, you will have the exclusive right. So it means from 2042 will may get my invention loses the patent. So not like that. In 2042, you can again go for renewal. of your invention, right? So the maximum period of patent is 20 years. Then third point that you have to notice with regard to the patent rights is it is a territorial right. Right? Territorial right means what? It is confined to a geographical location, geographical limits. Say for example, you are going to get a patent from Indian Patent Office, means it is valid only within India. You cannot go to Australia and claim I have a patent. No, if you want to protect your idea in Australia, you have to get an Australian patent. So it is a territorial right. Right? So will they give this patent right to me at free of cost, sir? No. There is a certain fees which is applicable. You have to pay that particular fees to the IP office, right? To ensure that the patent is in force. Say for example, you are not going to pay the money means they won't give you patents. And don't think, sir, which means I'm giving money, so they are giving me patents, sir. Not like that. This is just to maintain the patent in force. Right? Then there are something called as patent databases, right? Our IP office, they maintain patents databases, which is serving as a source of technical information. Say for example, you want to know something, is there any invention happened in such kind of a place, means such kinds of an area, means you can always go to patent database and check out what are all the new inventions that has come up. Now you will ask me a next question. Sir, I have invented a new machine and I have got the patent, sir. Now I also have some related inventions, sir. I have developed a new version of my existing patent, sir. I already have a machine, I have got patent, sir. Now, based on this machine, now I have also come up with a new machine which is based on this, which is like an improved version of my existing machine, sir. So can I get patent also for that? The answer is yes. Related inventions are also patentable, right? Related inventions are also patentable, right? Related inventions are also patentable. So this is what is called as a patent. Normally for scientific inventions and innovations, patents will be granted, right? For scientific inventions and innovations, patents can be granted. But today, even patents are coming up from social sciences like commerce and management background. But it is a very tedious process because some amount of novelty should be there. Otherwise, you cannot get patents in commerce or management. Right? So this is with regard to patents. Now, next comes trademarks. Right? Sorry, trade secrets. Sorry, not trademark, trade secrets. What is mean by trade secrets? For example, today there are only two soft drinks company in India which is dominating the entire soft drinks market. What are those two companies? Can anybody tell me? What are those two companies which is dominating in soft drinks, like cool drinks, all such things? What are the two company which is dominating the market today? Anybody? If you're not able to unmute also, you can put it in the chat. Can anybody tell me what are the two companies, right, which is dominating the cool drinks markets in India? Two company. Can anybody? Excellent. Pungadi madam, super madam, Coca-Cola. Then one more. Coca-Cola coming means automatically another one also should come.
Pepsi, sir.
Super madam, super. Right? Coca-Cola and Pepsi. Right? These two are predominantly dominating the soft drinks markets in India. Now, say for example, I want to start a new soft drink company. Right? I want to start a new soft drink company. Why Coca-Cola and Pepsi are very popular. Why they are so strong in India while others cannot venture? Of course, Kalishwari is coming, but still these two are dominating. Why? What is the reason? Because of the trade secret. What is the trade secret? Which is nothing but the formula, scientific formula. What is that formula, sir? Formula which they use to for their soft drinks. Why people are preferring Pepsi or Coke? Because of the maybe one reason, maybe the taste. That for that particular taste, these company have a formula. Right? These company have a formula which they won't reveal. What will happen if they say this is the formula means? I will copy that formula. I will also start the soft drinks company. So such kinds of things we call them as a trade secret. Right? What is trade secret? Any information which is commercially valuable. Right? Commercially valuable. If Pepsi or Coca-Cola is going to reveal that scientific formula to everyone, what will happen? Everyone will copy, the competitors will copy, and they will make money. So Coca-Cola and Pepsi has every right to protect their trade secret. So that is called as a trade, because this is commercially viable information. Suppose again there is a conflict arises. Sir, should this idea, can I file for patent or can I file for trade secret? It is up to that particular company. Say for example, I want to protect this idea with a patent means, right? Normally people don't go for patent for these kinds of idea. I'll tell you the reason why. Right? Because if you see the patent process, we are going to see what is the procedure for filing the patent in India. Right? When you file for a patent, you say this is my scientific idea, I want to publish a patent, I want to get a patent means, they will publish in the Indian Patent Journal. Right? Patent will be published, and after publication, if there is no objection, they will grant you the patent. So what will happen? When you publish this trade secret information, automatically what will happen? Right? People comes to know about your idea. So for that reason only, sometimes these scientific formulas, companies don't approach for patent, though they are eligible for it. Instead, they will protect their idea through this trademarks one. But in case if you're still going to go for patent application, then you cannot file an application for protection of the trade secret. You cannot call it as a trade secret. When you file that idea for application in patent office, no longer it becomes a trade secret, because for granting the patent, they will publish that in the particular patent journal. So when it is going to set before for your public display, no longer you can claim it as a trade secret. So it is up to the company to decide whether I'm going to go for I'm going to go for a patent or for a trade secret. So this is with regard to trade secrets. Now, third comes the copyrights. What is copyrights? All your artistic work, computer programs, web designs, right, recording, everything will come under copyrights. Right? What was the recent copyright issue which was quite so popular in Tamil Nadu? Maybe one person has unfortunately he has left us. Right? What was the copyright issue?
SPB sir oda music sir.
Super. Right? Very good. Right? Ilayaraja and SPB sir issue. Right? Most of us aware. Right? What Ilayaraja sir was saying. How can you use my music and songs without my permission? That was burning at that time. Right? So that is called as a copyright. So all for your literary work or dramatic, musical, recording, artistic work, that is also an intellectual creation, right? That is also arising out of your mind. So they are liable to protect their work. So when you are going to use their work, you have to get, right? You have to get their permission and use it. Or no problem. Otherwise, no problem. If you are getting permission and they are allowing you, no problem. Without permission, you should not do. right? So all these are the copyrights. For these works, we cannot go and file for a patent or trade secret. Instead, we have something called as a copyrights. You can file for copyright even for your research papers, right? Many journals, if you find, they will ask you for copyrights, copyright form. When you submit a research paper, they will ask you, the authors, to submit the copyright form. All right. So for all the literary artistic work, we have copyrights. And the point to be noted with regard to copyrights is that it protects only expression of idea, but not the underlying idea. What is that expression of idea? For example, let us take music, right? If you take music, expression of idea is only given the rights, like that particular ragam, talam, right, which Ilayaraja uses, right? That is only given the protection, but not the idea itself, right? So the expression of idea is only given protection under copyrights, not the underlying idea. Now, how long, sir, this copyrights is valid means life of the author plus 50 years. What is life of the author plus 50 years means? Say, for example, I'm going to get a copyright means till my death plus 50 years, this copyrights are valid. Maximum they can grant till that. Copyrights is so useful because it gives you a control over economic use of your work. So without your permission, people cannot use that and make money, right? And it also protects the moral rights. It protects your integrity, right? It protects your integrity, honest author reputation and integrity. It protects your reputation, because if somebody is going to use your work and they are doing it something wrong, means whose name is going to get spoiled? Only your name is going to get spoiled, right? So it also protects the moral rights of the author, right? So that is copyrights. Then comes trademarks, right? Then comes trademarks. What is trademarks? Any kind of logo, symbol, names, drawings, shapes, picture, which is having a commercial value, right? That is called as a trademark. You have designed your own logo. You have defined your own taglines, letters, pictures, shape. Here I have given you so many examples of trademarks. That
So,
Mahindra logo. Yes, yes, madam.
so you say trademarks are the name of the under design, sir. What about the design?
Design is also part of the trademarks, madam. But if it's going to be an industrial design, then that is a separate category.
Oh, okay, sir. Okay.
Okay, so instead of using the term design, they are using the term here as shapes, because we have a separate classification called as industrial design, right? So all these things constitutes your trademarks, right? The way that data is written, right? That Mahindra logo, Yahoo, all those things are eligible for trademarks, right? So again, trademarks, it will be granted by only the regional or national trademark office. Normally for your trademark, protection is given for 10 years, after which you can renew it, no problem. You can renew it for n number of time, and for which you have to pay a prescribed fees, right? So that is with regard to trademarks. So many IPR violations you can find only with regard to the trademarks, right? Because normally people don't notice the symbols or these kinds of logo very thoroughly, right? They don't look into it very thoroughly, right? So suddenly small change they will make, and we will be cheated. So you have to be really careful with regard to the trademarks. Then comes industrial designs, right? Industrial designs are nothing but an ornamental or artistic aspects of a product. For example, you can find, right, you can find a Coca-Cola bottle, right? You can find a Coca-Cola bottle. This bottle is protected by Coca-Cola company. The shape of the bottle, the height of the bottle, right, the inch and width, everything is now being protected by Coca-Cola. So you cannot manufacture a similar bottle like this, right, with specific height, shape, all those things. It's been prescribed by the Coca-Cola company. Then the right hand side, you have a cover of an iPhone, right, which is again also a protected industrial design of Apple company. So such kind of a thing we call this an industrial design, right? So industrial design, only the design matters. It does not take into account the technical or functional aspects of it. Only the shape is given, right? Only the shape is given the uh, protection. Again, it will be again you can approach the national or regional application for getting it done. Then protection is given for 10 years and it can be renewed at the designated times. So this is with regard to industrial design. Next comes others category, right? Others category, right, consists of maybe a short-term patents or a petty patent or innovation patent like utility models, right? Your business model can also be patented for a short period of time. Maybe after that, only when the business grows, the patent may not be granted. So those things we call them as a short-term patents, right? Small adoption of existing products, utility models, just a small variation, but those patents it won't be granted for the lifetime, maybe for a short time, right? You can get patents, new varieties of plants, new breeding, layout designs of integrated circuits. If you take Intel processor, no, Intel processor and all is an example for layout design, right? We call this as an integrated circuits, right? If you take compute an Intel core processor, all those things are examples of integrated circuit, which can also be protected for and can also be claimed as IP, intellectual property. Then you also have one more thing, which is called as a geographical indications. What is this geographical indications? Geographical indications is nothing but certain places is known for certain kinds of products. Can you give example? I give one example, right? Kanjipuram silks, right? When people want to buy silk, right? They'll often say Kanjipuram pattu padave, means super. Pattu padavanale Kanjipuram da, right? Then Nilgiris tea or Darjeeling tea, right? So all those things are an example of geographical indication which are also liable for protection, right? Which are also liable for protection. Likewise, we have for many places we have certain identities. Those things can also be filed for protecting for IP, right? So that is called as a geographical indication because product from that particular place has its own uniqueness, own special characteristics compared to the same product which is available in other geographical locations, right? So that is geographical indication. So all these are different kinds of IPRs, right? IPs, and you have rights over everything. You can file the creator, he can file rights over all these kinds of inventions, right? So that is geographical indications. Now let's come to the second part of our talk today, because I have been given like intellectual property rights and IP management for startup. So if you are as young people, right, I strongly suggest all my dear students here, be a job creator rather than a job seeker, right? Be a job creator rather than being a job seeker. You try to create jobs rather than looking for a job. That's what I'm trying to say. For which entrepreneurship is a very good way of means of creating the employment opportunities, and you can also start your own startups. Now you can ask me, sir, if I'm going to start up, I'm definitely going to face these kinds of challenges when I'm going to start my own business. How can I protect it? How can I protect it? So, with regard to IP management for startup, there are three main areas which the startups today have to focus on. One, they have to first understand whether they are a IP generating startup or an IP consumer. IP means intellectual property. Okay. So the startups today should first understand whether they are an IP generating startup or an IP consuming startup. So this understanding they should have as a startup. Then they should also assess their technology readiness level, TRL, as claimed by WIPO, World Intellectual Property Organizations, right? Technology, what is the technology readiness level of the startup? Then what is going to be your business plan or a model? Then how this IP can be integrated with your business model or business plan. Then later we talk about how to protect and manage all these things, right? Yes. So first let's see what is an IP consuming startup. What do I mean by IP consuming startup? It is a startup, it has business idea, but it needs a technology to exist. Best example, Uber. What is the role of Uber? Do you think Uber owns car? Uber company, you are aware, right? Uber company. What is the Uber company? What is the Uber company doing? Anybody? What is the Uber company doing? Yes. Uber company. What is the Uber company doing? Yes. Yes, madam. Pungadi, madam. Please, madam.
So, call taxi.
Excellent. Super. Call taxi company. Yes, Magesh Pugal, you have raised your hand. Yes. So what is this Uber company? Basically a call taxi company. My question is so simple. Whether Uber is owning cars. ஊபருக்குன்னு சொந்தமா நிறைய கார் வச்சிருக்காங்களா? அவங்களுக்கு நிறைய டிராவல்ஸ் கம்பெனி மாதிரி கார் எல்லாம் வச்சிருக்காங்களா? அதுதான் என்னோட கொஸ்டின். எஸ். Whether Uber company is owning car? Answer is simple, no. Yes, madam. Thank you, madam. Uber is not owning any car, right? But they are doing, they are using the technology, right? They have a very business innovative idea where they want to integrate all the car owners or those who want to make use of their cars businesses, and through a technology they are integrating and providing their services. That's all they are doing. This is called as an IP consuming startup. Though today it is not a startup, it has now become a very well established company, right? But an IP consuming startup means it has a business idea, but that needs some technology to exist, right? So that is an IP consuming startup. So they don't have to commit too much involvement in research or development, and they do not need to generate any IP. They are not going to invent something new, right? But only thing, they are utilizing the existing technology because that technology is an intellectual property, right? Google Maps, for example, is one way, it's one kind of technology which is an IP of Google company.
Sir?
Gautam? Gautam? Some network issues நினைக்கிறேம்மா.
Yes, ma'am.
Just wait for a second, he'll be back.
Sorry, there was a power cut here, so my net got disconnected. I'm so sorry for that.
No issues, no issues. Carry on, Gautam.
Yes. Okay, fine. So just is my screen visible? Yes, fine.
Yes, sir.
Yeah, thank you, madam. Thank you. So this is called as an IP consuming startup, right? They use the existing technology for they have a business idea, but to materialize that business idea, they would want to have the technology. So normally your internet startup company or an application development companies, internet marketplaces, all those things are an examples of your IP consuming startup. Next, you have something called as an IP generating startup, right? Their core business is revolving around IP itself. For example, best is an Apple company. We all know Apple company, right? So this Apple company is a best example. When it was started, it was an IP generating startup because their entire business revolves around the core IP. Why Apple is so popular? Today the competition is always between what? Mac and Android, right? Because the technology, these people are generating software's technology. Why Apple is so costly or Mac is so costly? Because those operating systems are known that it cannot be pirated or cheated, right? It is very difficult to access Apple. It is very difficult to hack an iPhone, right? So those things are IP generating startup because their entire business revolves around the core IP, right? Everything revolves around the core intellectual property. And their business, these kinds of startups, they will focus on technical solution. For example, take example iPhone. Android is capable of hacking. So they came up with Mac. So there is a problem. So for which this Apple company is developing a business idea with an iPhone, with a Mac software, and they are providing you a technical solution, and this Mac should not be copied by anybody else. So they are protecting it with the patent. So this is called as an IP generating startup, right? This is called as an IP generating startup. So best examples would be early stage technology, right? Normally any startup, when they are developing new technology, it is always developed to file a patent and get it protected because you are just a startup. You would face so many challenges in the business environment. People will try to copy your ideas, so better get it licensed, all these things. So that is an IP generating startup. Next comes, so this is what I would like to tell you with regard to what is an, now I told you the very first point, what is an IP consuming startup and what is an IP generating startup. Now, the next important phase, which the startups today for better IP management, they should know what is their technology readiness level, TRL, right? So there are different levels. Totally, I have shown you 6 levels. So they should know at which level they are there. Are they in the very beginning stage where they are involving in the basic technological research? or they are in the second stage. They have sufficient research evidence to prove that the technology which I'm going to develop as a startup, right, it has feasibility, it has an application, it will be proving successful in the market. Then gradually they can think about technology development. Yes, I have conducted my basic technological research. I have proper research evidences to prove that my technology will be successful. It is eligible for my protection under IPR. So now I can go for technology development, right? What is the stage? So this is like different stages in which startups can go. Then technology demonstration. Yes, you have developed the technology. Show me how this is going to be useful, because you are the creator of that particular technology. Tell me how this is going to help me. Technology demonstration. Then to ensure that technology is working properly, you have to develop adequate infrastructure or as a subsystem development for it to ensure the sustainability of the performance of the technology. And finally, you can run a test and launch your IP. Right? So these are the, so any startup should know at which stage they are in. Right? Whether I'm just in the very low end of the step or in the top step, or I am stagnating in between. So if startups have this idea, I will definitely say I think they can easily match up the technological, they can better manage their IPs. Now comes another important point of concern among the startups is with regard to, should I have a business model or a business plan? Right? See, a business model is basically a framework for identifying and creating and delivering value. What is mean by value? Value means I pay money, I should get something which is worth for it. That is what we call it as a value. So in business model, initially you are requested to have a model, then you can develop that, you can push that business model into your business plan. Right? What is a business plan? It is a more detailed view. In business model, you say this is a model, this is my business, how I'm going to plan and carry out my, this is like a framework, that's all. But plan is more detailed, how you are going to implement your business model, how you are going to sustain it in the long term. As a startup, you should have all these things, right? So business plan is more essential, which can be very much successful when you have a business model. And you have to try to integrate your IP strategy in your business plan, right? You have to integrate your IP strategy in business plan in such a way. When you integrate your IP with business plan, automatically it would be also be integrated in your business model, right? But when you integrate IP with business model, there are also chances it may not be integrated with the business plan. That's why we say integrate your IP with the business plan, so automatically it will support the implementation of the business model. So a startup should have a very good business model, and in the gradual phase they have to convert that business model, they have to integrate that business model into business plan, where they integrate the IP also, right? So this is with regard to business plan versus business model. Now next important area that we are going to focus upon is protecting startups' innovation. How startups can protect their innovation? How they can do this? There comes the concept of getting your right, which is called as a patentability, innovation, invention, patentability. So this is, I'm going to talk in the Indian context, right? If any startup wants to protect their idea, they can always file patent in Indian Patent Office. So what is the patentability which the Indian Patent Act talks about? It says an invention relating either to a product or process that is new, involving inventive step and capable of industrial. That's why I already told you there should be an industrial application, there should be some novelty. If you have these things, then your innovation is eligible for patenting. So what are all the criterias which this patent is giving? What are the criterias of patentability? First one, novelty. Novelty means something unique, original should be there. Then inventive step and non-obvious. Non-obvious means it should not be repetitive or it should not be something which is already in there. Then it should be capable of industry application. Very much important. Some industry should use your invention. If it's not going to go and give you the enough industrial application, then your invention may not be patentable. And it should not attack the provisions of section 3 and 4. We don't want to go into so much of that because it's a law. So it will be boring, right? And the Indian Patent Act clearly given what and all items which are not patentable. It has clearly given. There are two ways in which the law will express anything. Either it will say these are all the things which is allowed, or the law will say these are all the things which are not allowed, which means other than that everything is allowed. That is the understanding from the law which we have to look up. So the first one, which are not patentable items, the Indian Patent Act clearly gives you the thing, right? Literary, dramatic, musical, and any other artistic work. So they are not eligible for patent. What they are eligible for? What they are eligible for? Literary, drama, musical, and all. They are not eligible for patent, which means they are eligible for what? Yes, we just saw today in the today's session. They are eligible for what? What kind of protection they can get for literary, dramatic, or musical work?
Copyright.
Super, madam. Right? Copyrights. So they are not eligible for patent, which means they might be eligible for something else. Right? Don't think which means they don't count for invention. They might be eligible for some other protection. Right? Then mathematical programs, business method, computer programs, right? They are again not eligible for patents. Mere scheme, right? You are preparing a completely a beautiful scheme. Say, for example, you are working in a M&A company. What is a M&A company? M&A services company. Thomas, M&A means what? M&A means mergers and acquisitions. Today, do you know there are many banks and companies which are providing major and mergers and acquisition services, right? For example, you are working in such kind of a company, sir, and you are telling me, sir, I have developed a very innovative scheme for merger, sir. I have created an innovative scheme for acquisition, sir. So can I get that patent, sir? No, you cannot get patent for such kind of thing. So a mere scheme, rule, or method, or a mental act of playing a game, right? All those things are not patentable. Then mere presentation of informations. Just I'm going to present this fact, sir. It was not at all shown, so I'm going to present that information. Then that is also not patentable. Topography of integrated circuits, it's not eligible for patent because we have a separate category for integrated circuits. There you can protect your integrated circuits. Inventions related to atomic energy is not liable for patent. Otherwise, what you will do? People will create a new innovative atom bomb, right? They will get a patent and they will threaten people. So for these reasons also, though it is an invention, they are not giving patents for that, right? Then traditional knowledge of duplication of known properties, right? In our commerce language, I will tell you like product differentiation, right? Product differentiation, traditional knowledge, all such things are not patentable. Then biological process for propagation of plants and animals, right? How you find out how a particular organism is developing. The biological process you are finding out and you are claiming to patent. No, that is not patent. That is not invention, right? How a human grows, how an animal grows, how an organism, how a plant grows. It's a biological process. You cannot claim patent for that. today, if you want to file a patent, there are different ways in which this patent application can be taken forward. So there are 6 to 7 varieties of application. First one is an ordinary application. What is an ordinary application? You file an application with the Indian Patent Office. You don't claim any priority over an foreign country's application. So that is called as an ordinary application. You can find all these things in the patent publication. I think nowadays people are giving a patent certificate. Right there you could find evidence an ordinary application, convention application, PCT application, right? So that is an ordinary application. Then comes convention application. What is a convention application? This application can be filed by country if you are a member of Paris Convention. There is something called as Paris Convention, and when some countries are member of Paris Convention, and if you are part of Paris Convention, then you can file through the convention application. Then people also sign something called as a Patent Cooperation Treaty, PCT. What we call it as a PCT, Patent Cooperation Treaty. In Patent Cooperation Treaty, if any member belongs to that patent cooperation treaty, they have signed that particular thing, then that particular country can apply for patent through that PCT, national phase application, patent cooperation treaty. So this is the third way of application. Normally we people, individuals will go for ordinary application only, right? Because countries can also claim for patents. Then divisional application, this is nothing but a further application of the first mentioned. The normal ordinary application, if it's going to happen in a divisional areas, then we call it as a divisional application. Then patent of addition. What is patent of addition? I was telling you, right? So you already have a patent with you and you have come up with a new machine, which is an improved version of the existing machine. Then you can also claim patent for that. That thing we call it as patent of addition. Then provisional application. What is provisional application? Your invention is still in the experimental stage, but you still want to protect it. You are in the process of invention. You have not yet complete the invention, but you are in the process of invention. Then you can file a provisional application with the Indian Patent Office for the patent application. Then PCT international application, say for example, sir, I want to file only one application, but I want to get a patent from many countries. Only one application, but I want to get patent from many countries. Simultaneous application. That you can do if you are a member of country of Patent Cooperation Treaty, which is an international application. Through one application, you can file for patent in more than 150 nations. Only one application, but patent will be granted if your thing is accepted, which means it is valid in 150 countries. If you are going to ordinary application, means you have to file a separate application in India, separate application in Australia, right? And from academic perspective, from institutional perspective, try to file patents, because I heard even in NAC or NIRF, right, they are giving value even for, they have a separate valuation for patents filed, then patents published in the patent journal, and pay for patents granted. So if you have any invention, if you have any novel idea, try to file a patent, because that also adds a value to your profile as an individual, as a professor, as well as it also contributes for the institution purpose also. Because I think they are giving this bifurcation, patent published, patent granted. So when such facility is there, getting a patent published today is not a big deal, but getting it granted is a very huge task. But getting it published is a very easy one, unless provided you have an innovative idea. So all these are different kinds of patent application. So what is the patent filing procedure? It has so many technicalities involved, so I'm just going to give you an overview, right? Drafting of patent application, then filing the patent application with the patent office. So once you file that, they will go for an initial review and they will publish the patent application. This publication has a value in your NIRF or NAC for institutions, right? That's so. This is what they call it as patent publication, right? This one. After the publication, they will wait for 18 months to examine that application, and if there is no opposition, they will go for granted of patent. So there are two things with regard to ranking for institutions. One, publication also has value, and another one, grant also has value. This has more higher value compared to this, but still this has a value, right? So this is the general overall procedure. So overview of applications, if you want to file an application, you have to fill form number 1, which is available in the IPO. You have to specify provisional or complete specification. Please refer Indian Patents Act. They have clearly defined what is a provisional specification, what is a complete specification. Then you have to file a statement undertaking under section 8, declaration as to inventorship, form number 5. And for startups and small entities, it is for form number 28. So these are some of the forms through which you can file for your patent. Then once, say for example, you file an application and you got your patent granted, still after the patent being granted to you, it can be opposed. It can still be opposed, right? So what is the procedure for post grant? What we call it as post grant opposition. After the grant, people may still oppose for granting patent to you. So which is, there are 4 procedures, 5 steps. Notice of opposition will be first issued by the IPO. Then people will check for grounds for post grant opposition, whether the particular opposition qualifies for post grant opposition. If they find there is some prima facie which is there for post grant opposition, then that IPO will form a committee which they call it as constitution of the board, and that board will hear the arguments of both the parties, the inventor as well as the opposer, and then appeals will be given. So what are all the grounds for post grant opposition, and what case grant may be opposed by the other party? If you have wrongfully obtained the patent, then people can file for a post grant opposition. It is already priorly published, it is already claimed, it is of previous knowledge, there is a traditional knowledge, it is a non-patentable subject matter, but still you are getting a patent. There is no proper description for the invention, it is quite so vague, but still you are being granted a patent. Time limit, biological process, most of the things are non-patentable items. So on all these grounds, patent may be, grant may be opposed. Sometimes after hearing, the patent which has been granted to you can be revoked. It can be taken back, right? IPO will withdraw the patent grant which is given to you. In what circumstances they will do this, right? Inventions with similar specifications, right? If they find there are similar invention, but unfortunately have been granted patent, then they can go for revocation. Patent grant is given to a non-inventor. He cannot properly justify his invention. He just paid money and got the inventorship. Then patent grant may be non-inventor, wrongfully obtained by another person. No actual invention is there. There is lack of novelty. And after certain period of time, your invention is not at all in usage. I told you, for getting patent, industrial applications should be there. And industry application is not there, which means invention is not in usage, means then they can get back, they can revoke their patents. Again, lack of inventive steps, right? Personal documentation, false representation, non-patentable matters. Again, all these grounds, your patent can be revoked, right? The granted patent can also be revoked. That's why an inventor should be really careful. If you are really inventing something, please go for patents. Otherwise, you will get caught in the post-grant opposition. When you buy some inventorship for paying 8K or 10K or getting first position, second position, third position, means once it is going to be get granted, this will spoil your reputation, right? If people find that you don't know about the patent which has been granted to you, if you are properly defend, right? So this is with regard to revocation. Then for copyrights, filing of application, examination of application, then it will be copyrights will be published in the newspaper only for artistic work. But here opposition comes before itself. All right. People will check for any opposition, and if there is no opposition, copyrights will be automatically granted. All right. What constitute copyrights infringements? Making copies. Normally, what we do, we take Xerox copies of books, right? Which is also a copyright infringement. Making infringement copy for sale or hire or selling or letting them for hire, right? We take photocopies of our books. It is also subject to copyright infringements, right? Permitting any place for performance of works in the public without getting prior permission, you are doing it in public, which happened in case of Ilayaraja and SPB, right? He was performing Sir was performing the music of Ilayaraja in a public place for which only Ilayaraja claimed the copyrights, right? Distributing infringing copyrights for trade purpose, right? Copying infringements through public exhibition, importing all these are constitute copyrights infringements, and you are liable for punishment. Minimum imprisonment for 6 months. If you are if you are proven guilty of copyright infringement, minimum punishment is 6 months imprisonment with a fine of 50,000 rupees. If you are subsequently going to repeat the same means, still the punishment is for 1 year. Minimum, I am talking minimum, not maximum. Okay. You might think, sir, 50,000 only now people will do and go. No, sir. It's only the minimum. Law will decide what is the maximum thing. Right? Minimum, if you are going to repeat the same thing, then the minimum imprisonment will be for 1 year and for a period of 1 lakh. Fine of 1 lakh. Then trademarks, you can also file for trademarks. You can file application. As soon as you file the application, objection, people will scrutinize your symbols or logos. Then they will if they find everything perfect, they will publish it in the journal. After publication, if there is any opposition is being raised for any sort of your in shapes or logos or taglines, then it may not be granted. If there is no opposition, then automatically trademarks will be given to you. So how IP startups can exploit the intellectual property? How startups can use strategic ways? How startups can strategically exploit their IP resources, intellectual properties? All right. First, they have to classify their IP assets into these categories. All right. Especially, I'm talking about IP generating companies, IP generating startup, because IP consuming startups, no issues, because anyhow they are going to use the existing IP only. This IP generating startup, how they can exploit in the sense how they can best utilize, optimally utilize their IP. They can categorize their IP assets into 4 categories, which is critical to the company. One best way to exploit the IPs is through the licensing. You can give license and make money, right? Like what McDonald's or one more thing is there, no? Domino's. These people are only doing the licensing. They are exploiting their IPs through these ways only, right? You can classify your IP assets into 4 categories. What is critical to the company? If one particular IP asset is very crucial for your success of the company, please don't license it. Please retain yourself. Startups can retain that. It is a very crucial asset, but still it is very important for public purpose, public good. We can, for example, vaccines, medicines, they will fall under this category. In that case, you can license. If it is not going to be critical, they are not so much critical, but they are still useful for the company, you can go for licensing. Okay, not critical. This IP, out of this, then 4th category of IP is IP which is not useful. If you still want to retain it or divest, right? Divest means sell it off to some other company which is looking out for that, right? So these are some of the ways through which how startups can exploit, especially the IP generating startup. They have to first classify their all the IPs they have assets into this fourth category, and they can strategically make use of their IP for their commercial purpose. So again, you can also exploit the patent databases, especially for IP management startups. You can look out for patent databases because it helps you in avoiding the duplicating of works, assess the potential of an invention to qualify for patents. It helps you in avoiding infringing any third-party patents, and patent databases can help in startups in assessing the competitiveness, how far they are strong in the content in the market, what is the uniqueness of their IP invention. Exploit technologies in the patent application, gather intelligence. You can plan for how the future going to be happening. Improve the planning for your business decision. So patent databases can really help startups in these ways. So I hope I have done a justice to the topic. If startups can follow these kinds of practices, I think they can better manage their IP, which will be of commercially valuable for their businesses. So I once again extend my sincere thanks and gratitude to the entire management team and organizers of Aglandeshwari College for Women for having organizing this wonderful workshop on intellectual property right. I feel I have done a justice to the topic. So thank you so much. If you have any questions, I'm ready to take up. Over to organizers. Thank you. Thank you so much.
Thank you so much, Gautam.
Thank you, ma'am. Thank you.
It's really eye opener for all of us.
Thank you, ma'am. Thank you so much.
Thank you so much. Thank you, Gautam. Thank you.
Thank you, sir.
Thank you, ma'am.
On
Thank
behalf of our management, my personal thanks to you.
Thank
Official
you.
thanks will be there.
Yeah, thank you, ma'am.
Students, anybody, any clarification, you just ask him. Students and faculty members, you can ask any clarification. அம்மா வரலட்சுமி இப்போ இது ஒண்ணும் இல்ல அப்படின்னா கொஸ்டின்ஸ் இல்லைன்னா vote of thanks சொல்லுங்கம்மா.
Okay, ma'am. Okay.
ம்.
Now we must offer that life cannot be achieved without here.
Ma, anybody from faculty and one of the students, you can give your feedback. Unmute your mic and tell faculty about this webinar feedback. We need feedback. Just tell one more, one faculty, one faculty and one students. PG students will be there now.
Sir. Thank you for our
Unmute
opportunity.
your mic and talk.
Nice meeting, sir. Very useful, sir.
Introduce yourself and talk.
Thank you, sir. So thank you for those more presentation. Really
Thank you, madam. Thank you so much.
Now we must offer that life cannot be sure. Comes extremely concerned. This is A. Abhinaya, Assistant Professor of Congress BA, to deliver the vote of thanks.
It's my privilege to deliver the words of thanks on the occasion of the Department of Commerce Building, the Research and Innovation Club, the Aglandeshwari Women's College. First of all, I would like to thank God Almighty for blessing us for the success workshop for start. It this opportunity. Secretary,
பண்ணுங்க வரலட்சுமி யா கேரியன்மா
Yes, Dr. Rukumani, Principal Ma'am, and Vice Principal Ma'am, Ms. K. Suguna Ma'am, for giving opportunity to conduct this webinar. And I thank our organizing committee, Dr. N. Tamilarasi, Head and Assistant Professor of Computer Science, and IIC President, and also our department HOD Ma'am, Mrs. K. Varalakshmi, who supported a lot. And I sincerely thank our chief guest, Mr. Gautam Sir, Research Scholar, Department of Commerce, College of Science and Humanities, SRM Institute of Science and Technology, Katangulattur, Chengalpet, who has given a fruitful speech about the workshops on intellectual property rights and IP management for startup. Thank you, sir, for sharing your valuable time and knowledge with us, which was really useful for us. And last but not least, I sincerely thank our faculty members and beloved students. Thank you, everyone.
Thank you, Gautam. See you. Thank you.
ma'am. Thank you, ma'am. Thank you so much.
Thank you.
Thank you, sir. Thank you for valuable time spending with us.
Thank you,
Thank
ma'am.
you, sir. Sharing your valuable information, sir.
Thank you, ma'am.
Thank you so much, sir. Okay. No, right. Aloe area. இங்க வா இது பேஸ்ட் பண்ணு காப்பி பண்ணவே வர மாட்டேங்குது
எது
Hey.
ஹஸ்பண்ட் கேக்குறான் இருங்க நான் ரெக்கார்டு இன்னும் ஆஃப் பண்ணவே இல்லை